Okay, now that we've done our rearranging up here on the podium, we're very excited to bring you our next two speakers, both very experienced trial lawyers. One from the plaintiff's side, Keith Bona is here in place of Mike Pontario. Keith has extensive trial experience with asbestos and also tried the lead paint case in Western New York that Judge Rosenbaum was speaking of yesterday. So we're very excited to have Keith here today. Mike is dare I say, we've been spoken at these events in the past. I'm sure he looks familiar to many of you. Yeah. We're excited to have Mike as well. He practices in the area of insurance defense, insurance coverage, and of course, lead poisoning. So we welcome them both.
Good morning. As I've just been introduced, my name is Mike Burgoyne, and I'm very fortunate to share the table here with Keith. Keith and I were talking a little bit about what we're going to do today, and what we didn't talk about was what we would wear. And Keith says, when I met him the other day, we're in New Orleans, what's with the suit, Mike? I said, well, I'm from Baltimore, and today's Purple Friday. So for you guys that don't know, we have a football team in Baltimore. But we have a topic that, as one of my colleagues said, you could land a 747 on that runway. This is very broad. And we're trying to figure out how to present the best information. And also, Brian indicated to us that we've got to not just talk to the people who've been doing this for 20 years, but we got to talk to the people who are new to this kind of litigation. And so I'm going to apologize if we're too basic for some of you, but hopefully we reach out to some of the people who are just getting started in this. We also had another discussion, and that discussion was, do I want to tell Nick, the way I think about cases? Okay? Do I want to give any secrets? Not that there are secrets, but to the extent I may have a secret. How much information do we want to give? And on the plaintiff side, it's the same thing. Whoa, wait a minute. Why am I going to tell these defense attorneys what the heck I'm thinking when I'm evaluating and analyzing in preparation for trial? And so it was really a game time decision. We were going like, how much do we tell? How much? But finally this morning over a cup of coffee, we decided what we're going to do. Thanks a lot, guys. No, all kidding aside, what we're going to try to do is run through this big topic. We have prepared some written materials. It's pretty extensive. It's in a lot more detail because I think that what we're going to both try to do is just pique your interest, maybe reaffirm some things that you already know, but maybe for some other people, get you focused in the right way. And please go to the written materials for some of that detail that we're going to just totally skip today, okay?
Just for the record, the written materials, I didn't produce those. Somebody from our office did. I'm sure they're very good. First and foremost, I want to thank everybody for allowing me to speak here. I am a bit of a rookie in this, in that I am an asbestos attorney. Mike Pontario would not be pleased hearing me say that, but I didn't get involved in lead until last fall. And prior to that, extensive asbestos litigation, trial work. And basically after we kicked the crap out of Ford last summer in a mesothelioma case, Mike Pontario asked me to start litigating lead cases with him. And I said, Mike, I don't know anything about lead. He said, don't worry, you'll figure it out. You're a smart kid. I said, all right, fine. So anyway, I want to thank Mike for allowing me to speak with him, and I want to commend you guys on your bar. Not only are you the best dressed bar I've ever been in front of, because the asbestos attorneys, they dress way worse than this when they go to seminars. but you guys are very, very tight-knit group. You're very, very knowledgeable in your subject matter. You know your craft, and I commend you on that. And I welcome working with you guys in the future. First thing we want to talk about is discovery. And with respect to discovery, and actually with respect to my entire presentation today, because I actually have more lead trial experience than I have deposition experience, I'm going to just try to put forth some of the ideas that I think were helpful when I did try the lead cases that I did. So first and foremost, discovery, digging deeper. What we're always trying to find, whether it's defense or plaintiffs, are the skeletons in the closet. We're always looking for the bad stuff. And how is this going to take my case off track? From the defense side, how do I neutralize the plaintiff? Where's all the baggage? Where are the skeletons in the closet? But when you prepare for trial, you have to be looking for the gems when you're on the plaintiff's side. What do I mean by that? There's so many things in the records that you can use to your advantage to help you thwart those defense arguments. And we'll get into some of those in a little bit. But I just want to tell a quick story about skeletons in the closet. Bench trial with Judge Rosenbaum last October. We had done all our discovery, trial subpoenas. We think we're good to go. We have two plaintiffs, brother and a sister. Brother takes the stand. He's about 5 feet tall, 110 pounds soaking wet. There's a reason for that. So under cross-examination, the defense lawyer starts talking to him, and he says to him, how you doing in school? Because school had just started. He says, good. He says, really, how's, your classes, everything? Good. Turns out he had caused a riot that shut the entire school down. We had no idea because it was in that last month of records that we didn't get before the trial. So as you can imagine, we're scrambling at this point. 110-pound kid, very soft-spoken, he shut the entire school down with a riot. Needless to say, we had represented to the judge that this is a good family, good kids. Didn't come out that way. We thought we'd be okay. We had the sister. Humility will win the day. The sister takes the stand. We told her, just be truthful, be nice, like you tell all your plaintiffs to do. Under cross-examination, do you play any sports? Yes, I play basketball. Okay. Are you any good? Oh, I'm very good, very good. Oh, do you like to go to practice? Do you like to associate with your teammates? No, I don't like to bother with that because I'm so good. Again, these are things that you got to look out for. You got to prep your clients. We did try to prep them. Sometimes it just doesn't work out that way.
When we kind of were talking about what this topic was, we kind of came to a title of Litigation Strategies, and as opposed to trial tactics, because let me suggest to you that in Baltimore, we've been tracking what the number of filings have been for the last 2 years for one of our clients, and there are hundreds of cases being filed every year in the last 3 years in Baltimore City. Okay, hundreds of cases being filed. I'm not talking about 150. I'm talking about 500 cases. It's an enormous number. When I look out and I see some of my brethren, we know that out of those 500 cases, some will get dismissed voluntarily, some will get dismissed involuntarily. We'll try some, literally just some, okay? So what are we doing with most of the cases that we're handling? We're investigating, evaluating, and with the help of some of our mediators and our judges, we're settling them, okay? And so the cases that get tried are cases that have problems for the most part, okay? Now the problems could be a lot of different things, but quite often the problem is one side or the other is not totally prepared. You know, working for insurance companies, you can't ask for a lot of money unless you've been telling them all along what the value of the case is. So if you're not doing the necessary investigation and you're not communicating, that case may get tried for no reason but that the reserves on that case are not adequate to settle it. So in the practice, in my practice, and certainly with a lot of my fellow attorneys in Maryland, and I suspect in other jurisdictions, the discovery and investigation that you do is so critical. To a certain extent, given the serious nature of these cases, more so than your average road wreck case. And so we're going to talk a little bit about the litigation strategies from each side that gets you to the point where you can actually evaluate the case properly and, if appropriate, resolve it in a timely manner.
And likewise, to expand on what Mike is saying, this is very consistent with upstate New York as well, except on the volume end of it. We don't have as many cases filed, I believe, as Baltimore does, but it's everything else is the same. A lot of them are just go and get ready. Very, very few go to trial. In the last few years, there's only been 2 in upstate New York. And again, what Mike, just to reiterate what he's saying, discovery, even on the plaintiff side, in evaluating a case is extremely critical when you start to negotiate. You got to know what you're talking about. You got to know the holes in your case, because you know Mike's going to point it out to you. So you better know what you're talking about before you go in front of the judge or the mediator.
In Baltimore, over the years, I lament the fact that some of our causes of action seem to be more strict liability than negligence-based, that the focus becomes less on who may be liable and more on causation issues and damage issues. But that's not quite the way it is in other jurisdictions. I'm always sad and happy at the same time when I hear from other jurisdictions that they still get to litigate things like negligence and reasonableness, and it actually means something. Whether it's venue or our appellate courts, it seems like some of those defenses have disappeared over the years. But like I said, when I was talking to Keith, I was amazed that the plaintiffs in other jurisdictions have to really work hard to get a case to the point where they're comfortable with the liability end of it. In Maryland, you know, a lot of times we're not so fortunate.
Yeah, and when Mike told me about that, the way things work down in Maryland with respect to the negligence aspect, I was thinking about picking up shop and moving down to Baltimore. I got to tell you, having proof of exposure, you know, in a violation of a statute being strict liability is just unbelievable. I believe personally, as an outsider, negligence is the hardest part of a plaintiff's case, at least in upstate New York. That's my opinion on it. Some people may differ with that. But we do have a lot of issues. We have the New York lawyers. I won't bore you with the Chapman factors, although right of entry has been a very hotly contested issue as of lately, and that's going to keep going. And negligent abatement is our other cause of action, but you got to show that the lead exposure goes up as a result of the negligent abatement. And my only discovery depositions in lead with Mr. Gary Abelson, we had that same situation. And, but anyway, let me just move on. I want to talk to you a little bit about the measurable effects of lead, at least the way I see them as a non-lead attorney. And first and foremost, my favorite thing is IQ. And I promise you, this is not one of my clients. However, I think he'd make a very, very good poster child for comparative negligence, in that he doesn't want to listen to the teacher whatsoever. In any event, IQ, what's so great about IQ? It's really the only quantitative item we have when we look at a plaintiff, all right? Something that we can actually play with and talk to a jury about. Doesn't matter if the IQ is higher or lower, I think you can still work with that. If you have a high IQ with the good lead exposure, good numbers, say in the 30s, you can argue the IQ point loss based on a lot of the peer-reviewed literature like Canfield, Port Peary, those studies. You can say, look, yeah, all right, he's got an 87 IQ, but if he didn't have the 35 lead level, he'd be into the 90s, and he'd be in that normal range. I think that's very persuasive to a jury, normal versus below average, okay? Likewise, if you have a low IQ, all right, it's easy. That's easy to point to a jury and say, look, there's the injury. Look at how low that IQ is. And that's a result of the lead exposure. And in addition to that, you know, even when you do have a high IQ, at least the experts on our side of the fence are willing to say you can still have a learning disability despite having a high IQ. These two things are separate, all right? IQ and learning disability is separate. You can have a very, very high IQ but still have problems with cognition, learning, etc. Next, I want to talk to you about school records. As for your purpose of measurable effects of the lead, your school records really can be your white knight. What do I mean by that? We talked about the skeletons you look for, but the gems that are in there in those school records, if you really look, you can find independent proof, unbiased proof of injury to your child. What do I mean by that? If you have a school psychological evaluation that has an IQ in it, if it matches up with your expert, great. If it's lower than your expert's assessment, dynamite. It's just dynamite. In addition to that, you look at the school records with respect to their evaluations. Are they categorized as learning disabled, IEP? All right, again, independent, unbiased proof of injury. Lastly, on that topic, you look for patterns with respect to their attendance, their grades, because we all know a lot of our plaintiffs happen to be truant a lot. But if you dig back and you look to the beginning of time when they first started going to school, what were their grades like? How much time were they spending in school? That's important. And most importantly, look at the school notes from the teachers and the psychologists. What are they saying? Child is working hard, just doesn't get it. Child was lead exposed. I've seen that in school records, okay? A lot of times, our plaintiffs get painted in the portrait of that they're lazy or they don't want to work hard. Those are very, very interesting items that you can find, and we've used in trial. We've gotten our butt kicked in court one day, went back, spent 4 hours putting together a PowerPoint of all the school records where it says your kid was trying very hard, working very hard in class. All right, and I just think from a trial standpoint, it's something you should be aware of. Look for those gems in there as a plaintiff's lawyer to combat some of the things that the defense will throw at you.
Okay, so no, we're fine. So how do you get this information? School records, IQ. IQ, for example, sometimes is a meaningless number, but when you compare it to school performance, you find out that this person who has a less than normal IQ is doing fine in school. It creates some kind of context for an argument that the IQ from the plaintiff's neuropsychologist may not be the gold standard for how this kid actually functions in the world. Because these cases are not theoretical, these cases are actual. And if you find children that are doing well in school despite a alleged low IQ, kids that are picking things up, graduating, getting all their necessary standardized test scores to pass Maryland schools, those things can counteract a lot of what the neuropsychologist may theoretically say is wrong with the child. In Maryland, we have broad subpoena power. We can go out and get the records, but I am a big proponent of independent investigations by private investigators. To the extent that I don't have to tell the other side ethically what I'm doing and I can get records, I'm way ahead of the game. So private investigation, subpoenas to get certain records, and then ultimately the depositions are essential in the case of the mother. You never want to see a child for the first time at trial, so regardless of the age, we depose the children as well. In the materials, there's a pretty good outline for a mother's deposition, and when you look at that, it's kind of a roadmap to some of these cases and how to defend them. But again, in these cases, the last thing you want to do is come up to the day of trial and find out that you missed something that your opponent now is using, especially in opening, as the cornerstone of their case. I had a case with one of the attorneys in this office where all the records that we got from high school on showed that this kid was doing great. And we forgot in that case to update all of our records right before trial. And we found out that in the couple of months that it took from April to September, that child had gone and had a horrendous school record. Performance was going to repeat the grade. It was just amazing how it went downhill. Now, there may be explanations for that, But if you didn't update and find that information, you are surprised at trial. And any trial lawyer, the last thing he wants to be is surprised at trial.
Yeah, and when Mike told me the way you guys work down in Baltimore, that all of this stuff, the parental education records, and you know, and is it true you can actually have the mom's IQ tested?
We haven't been too lucky on that lately.
Thank God.
There was a day.
But in any event, when he told me all that, I decided, on the other hand, I'm not going to move to Baltimore, Maryland to prosecute cases. That's tough. In New York, as my New York brethren and sisters know, that stuff is not admissible, all right? The parents' educational records, her medical records, all right? Child Protective Services records are not admissible at the time of trial. We have the Helmer case and the Angela case, which is for the CPS records. That's in the materials, I believe, as well. And that's huge. That's huge. I think any plaintiff's bar be handicapped with some of, you know, the baggage, if you will, or the arguments that can be drawn for some of the information that you could obtain from some of those records. And I'm thankful that I don't have to deal with that when I go into the courtroom at this point in time anyway. Another thing to talk about just briefly on special issues is prior claims. If you have I won't call him a slumlord because I know that's not the correct terminology, but another term we use is serial poisoner. I think that's a little more politically correct. And if you have a landlord on the other side that just has tons and tons of violations, generally those are admissible at the time of trial because it goes to the weight of negligence to see what type of person this is. It also goes to notice on the effects, the harmful effects of lead on children. So that's something that's also very important. And that goes to knowledge as well.
I'm making a note here. If Keith does come to Baltimore, all the motions in limine I got to file. So, in Maryland, you know, I'm a big proponent of motions in limine, and I think most of our defense and to an extent our plaintiffs' attorneys are filing them because some of these issues do become pretty hot button issues on not so much relevancy and whether or not it comes in, but whether or not it's unfairly prejudiced. And it seems like in other jurisdictions that is the touchstone of the negligence argument. What do they know? What's their prior history and all? To a certain extent, we're able to keep that out. So I guess the housing code at some point is a blessing and a curse at the same time. But the thing to remember for the newer attorneys is that the net that you cast out there in discovery, you know, we're not saying that everything we find in discovery is admissible, but you can never, you know, pare down your case if you don't find it. You can't make admissibility decisions or make decisions on what evidence is going to be persuasive unless you find it in discovery. And again, that's why we spend a lot of time and money and effort on the discovery to see what kind of gems we can get out of that process that can help us at trial.
Mike, I think this one's yours.
Yeah, it's, my wife said if you put little puppies and kittens in there, you'll get the oohs and ahs. You guys must have been drinking the same place I was last night. But the reason I put that in is because sometimes you gotta just resort to common sense, okay? Dogs don't make cats. I don't understand how familial type of issues don't become admissible and relevant in cases. And again, just because plaintiffs may fight you tooth and nail to keep you from discovering about the mother, the father, the siblings in a case, don't give up on that battle because there's a lot of times when that, in fact, could be some of the most persuasive evidence you have in trial that although lead may be associated with all these bad things, there's some predominant factors that are better explanations for a lay jury on why this kid is doing whatever they're doing.
I'll cover a little bit about inheritability later. Case evaluation. What are you looking for in your case? It doesn't matter if you're trying to settle the case or you're trying to prep for trial. You're looking to find out What are your warts? And most importantly, how do you change those warts? How do you defend those warts? I really feel it's bizarre to me because being in the asbestos world, I'm always on the offensive, I think. I'm always going after those companies because they were so bad and evil. But when I do the lead case, I feel a little bit on the defense. Like I'm trying to defend my client a lot, and it's kind of scary. But I'll tell you, that's just a real world approach from somebody who doesn't do this very often. But what are you looking for? I think your preparation is key. And besides the discovery and going through the paper, you have to go out and meet your client. You got to see if that turkey can fly. You got to go meet them face to face. What kind of appearance do they make? Can they get in front of a jury? Can they have humility? Can they keep their cool? Can the mom keep her cool when the defense lawyer is cross-examining her? Because if she can't, you're going to have real problems. Other things you want to look for, obviously, your lead levels. How do they fluctuate? Are there other houses involved and all that stuff that you guys know way better than I do, so I'm not going to bore you with it. Negligence, Mr. Dumpty here, failure to warn. Okay. Any event, you know, they definitely were drinking last night. None of this stuff was working.
We thought this was funny.
I thought it was funny. I hope there's some stuff later that you might get some kicks out of. We got some fun videos, I think. We'll see. Again, as I mentioned earlier, negligence is the hardest part of the case, in my opinion. And, you know, as great as it is to have lead paint violations and a bunch of them against a landlord, there's no strict liability. That is just some form of evidence of negligence under New York law. We still have to work hard to prove that negligence. All right, you got to keep going with it. Causation. You're going to run with this.
One of the slides that we just showed had the police car in the rearview mirror. And one word of caution to this bar is that sometimes we're always looking back and not looking forward. With our causes of action, you know, I represent a client that in 1984 started to put lead exclusions into their policies. Okay, I have a client that didn't do it until 2000. Okay, so there will be a time when the plaintiff's bar, they're celebrating the 5 level, okay, but at the same time they're not so much celebrating Roberts and the lead exclusion in Maryland. So what they're going to have to do if they want to be at this conference in 5-6 years is expand the causes of action and try to reach out to different defendants than the real estate investor that owns the home. So to a certain extent, we want to make sure that everybody's cautioned to look forward again to anticipate the next move. In the time when old folks like Frank Daly were first handling these cases, residential house paint was the issue because the level was 45 or 50. It was very hard. We were fighting about whether lead did anything, you know, but we weren't necessarily fighting as much as what was the source of the lead. But now, if you come 20 years into the future to today, and you have cases that are being filed, I have a case, and I won't mention what the plaintiff's attorney is, but they're sitting here, where the level was a 2, okay? And the expert has opined that there was a 1-point IQ loss for that exposure, okay? And so as you get cases like that, you've got to look at different factors and different things than what you may have done in the past. We're looking forward. Causation becomes a much bigger issue today than it may have been several years ago. In looking at causation, the source of lead is important. I would concede if a kid lived in a property for 2 years and had a 50 and we couldn't find anything else, it's probably household paint, okay? I will not concede that once we go to 15, 10, 5, or 2, okay, that the source of the lead is household paint. There's just a bigger group of potential sources than that household paint that can cause those kind of levels, even if that is a reliable test. Okay.
So to branch off of that, how do you show injury with these low-level exposures to lead when you got a 10 or a 15? And I got to tell you again, going back last year when Mike asked me to start doing the lead work, and I started reviewing the cases and talking about levels of lead in the blood, this little UG and BL kept propping up in the records I was looking at, and I said, what the hell is that? And so I went into Mike's office, I said, what is this? And he said, that's micrograms per deciliter. I said, okay, what is that? Because I don't know about you guys, but we're lawyers. I was never good with math, and I definitely wasn't good with chemistry. I had no idea what that meant. So I'm thinking to myself, I got to try this case, all right, with Mike and Neil. And I said, well, how am I going to explain this to the jury when I open? So I'm a big fan, and I learned this in asbestos, so you try and keep it simple. I forgot I added this last night. This is my reaction when he said micrograms per deciliter. Watch that one. I got to laugh. All right, good. So how do I explain this to the jury? This is actually from my opening statement. And the way I try to explain it is simply this. You got a gram, and use household items if you can, things that the jury are very familiar with. I said a gram, ladies and gentlemen. That's a sugar cube, basically. All right? Now, what's a microgram? That's that little tiny thing down there on the end. And basically, you got 1 million of those in a gram. Now, what's a deciliter? I had to look that one up, too. A deciliter is like 3.4 ounces or something like that. Basically, I say that's a glass of wine. So basically, if you dropped a sugar cube in a glass of wine and that was blood, you'd have 1 million micrograms per deciliter. What does that tell you about a 5 or a 10? We're talking about very, very, very small amounts of lead that can cause injury, ladies and gentlemen. That's how toxic this stuff is. And I think you use simple demonstrative tools like this when you try to explain these concepts that are very scientific and complex, and you'll get by just fine. And I think it worked for us. There we go.
Reliability. Again, quit looking backwards, look forward. As lower level cases are the stock and trade of the plaintiff's firm, there are all kinds of issues that were not so much big issues 5 years ago, 3 years ago. And one of the things that we find is that the reliability of tests, whether it's the testing that takes place on the walls of our clients' homes or the tests to determine blood lead. I think that our doctor yesterday said that the basic error of measurement 10, 15 years ago with lead tests was plus or minus 4. And now you're going to litigate a case where the level is 4. I agree with Patricia, that's a 0.
It's an 8.
But here's an issue that is potentially an issue that wins or loses a case that never happened when you were litigating cases where there was successive hospital admissions and pharmacological treatment for removing the lead from the body. So when you talk about causation, don't just give up on some of the basic challenges to some of this evidence and whether or not this evidence is credible and reliable.
Okay, I got non-lead insults. Anybody here not know what non-lead insults are? I thought not.
You were drunk last night.
Go ahead, Mike.
Oh, that's with regard to non-lead insults, again, as lower levels become litigated, you cast a bigger net, okay? Again, this is more for some of the novices in there. Just because a child has lead doesn't mean they got it from the paint on the house, or that they got it from the paint on the house while your client owned the property. There's a lot of additional sources for lead. We can take our surveys of the street where my defendant's house is, the playground where the kids may play, and we find levels that can be much more efficiently causing these low-level leads than what is claimed to be my defective paint. Okay, does that look confusing? Well, it is confusing, but it also illustrates a point that there are many, many, many factors that can come together to cause the alleged harm that you find in the case, and that they need to be thoroughly investigated. I don't advocate a shotgun approach to trying these cases, but I do advocate a shotgun approach to finding, through discovery, alternative causes for what allegedly I have to defend at trial.
And I would hope to God Mike would never use this in a trial. I know that he wouldn't, because you could have a lot of fun with this chart. Not only is it extremely confusing, but you have manufacturer of illegal whiskey in here as a causation, working with near a smelter. I don't think there are any smelters in upstate New York, but I get the point of it. It's good. So evaluating your damages, let me just run through this list real quick. Things you got to look at when you're trying to quantify this case, whether it is at the time of settlement or if you're going to ask a jury for an amount of money. You have to look at all these factors, the maternal factors that, if any of them do get in, that is, or just even in how the mom presents herself to the jury. The prenatal records, the trauma, factors affecting the testing results, mental illness, economic loss, caps, vocational, employment. All right. The one thing I do want to focus on with you people from New York is economic losses, okay? Under the LaFontaine decision, which I believe is in the information as well, you have to have foundation before your economist offers his opinion on what the losses are, all right? You have to have a neuropsych come in. He has to testify that this child's been lead poisoned, he's injured, and as a result of that injury, their work capacity is limited in some way, whether it be to entry-level jobs or, you know, some other facet of some sort of disability that the economist can then build off of using governmental charts for income statistics through the federal government. So you have to have that foundation. Now, when it comes to your economic damages when you go to trial as a plaintiff lawyer, at least in upstate New York, I know that the jurisdictions vary greatly as far as between Baltimore and Buffalo and Rochester on damages and what a jury will give, that's for sure. When I first got involved in this last year, and I was looking at the Ashley Hicks case, which Judge Rosenbaum talked about yesterday, I read the economist's report, and we had down for damages 2-year degree loss, economic losses based on a 2-year degree and a 4-year degree. And I took a step back and I went and I talked to Mike Pontier and I said, Mike, this isn't going to fly. You can't. I just don't think you can stretch a plaintiff that far sometimes. There are circumstances where you will be able to say, yeah, this person could have got a 4-year degree, but I'm just being honest. I think a lot of our lead clients, to say that they would have attained a 4-year degree, I think you're reaching a little bit too much, and that the jury may punish you for that because you don't look reasonable to them, all right? And a lot of times, even if you do high school graduate without disability, those damages, okay, where they're a high school graduate with disability, or a 2-year degree, the amount of economics that you get from your economist are close or over the policy limit anyway. And if not, there's still a reasonable number that you can give to the jury. And I think the key here is just not to stretch your economic damages. Reasonableness wins the day, in my opinion, in front of a jury.
That advice usually is not taken in Baltimore. And it could be, in fact, because we have a cap on the non-economic part of the case. So if a plaintiff wants to maximize the recovery, most times they take as a given that they're going to get the cap, okay? So they're focused on the economic loss. And again, as you'll hear, that's a fertile ground for debate and a fertile ground for challenging the experts. But it's much different. The other part that I'd like to just touch on here is that in most cases, educational attainment seems to be the measure of the economic loss. And I've had cases where we're not dealing with an 8-year-old plaintiff, but an 18, 20, 21-year-old plaintiff who has a vocational history, who has a job, even in this tough economy. Maybe it's construction, trade, entry level, but how can you equate educational attainment to damage when you have proven vocational history? It just doesn't make sense. So again, there's a lot of areas where we need to spend a little more time evaluating this economic loss because it becomes such an important factor.
Well, I think what you do with that situation is he would have been doing better. He'd have been making a little more money. He would have been a college graduate, you know, that kind of thing. The other thing I forgot to mention, pain and suffering damages. Do you guys have those?
We do.
Yeah. we have a hard, well, we had a hard time with the pain and suffering damages in our trial. In fact, we got a 0. And I think unless you have maybe a chelation or something, it's kind of hard for a jury to extrapolate those damages. I did my best in closing to try to say, you know, how her life was impacted, and you know, she won't be able to read novels straight through and stuff like that. It didn't work. And the loss of enjoyment of life is something difficult in of itself to prove and to argue to a jury. Even in an asbestos case where you got somebody who's been debilitated, you know, sometimes that's hard. But in these cases, how do you argue that damage? And I'm still working on that. If anybody's got any tips for me, let me know, because it's a tough sell in my opinion. Okay. Another one of Mike's charts.
Yeah. You know, I do believe in the KISS method, okay? But when I'm talking about discovery, which I think is so important, you've got to look at all these factors as potential issues for trial. You know, I tell all my experts that I want them to give me something I can hang my hat on, okay? I want to keep this trial as simple as I can. Now, sometimes you can't, but I want to make sure in discovery, I'm not just going with perhaps traditional areas of investigation. I'm looking at everything. You know, we spend a lot of time, and we have some talented non-lawyer people that go through these records, and it's amazing what we find. Plaintiff's counsel now is doing the same thing after they've been burned a couple times, but it's an exercise that must be done. Issue for the records, evaluate them in the context of what are potential impacts upon why that child may not be doing as good as expected.
Okay, inheritability issues, risk factors. I just want to throw a hypothetical out there to the audience. Okay, I want you to look at a hypothetical case with me, and we're going to look at some confounding factors. All right, we have a single teenage mom living in rental properties of low socioeconomic status, public assistance. Did not graduate from high school, and also smoked during pregnancy. Has anybody in here not seen a case with similar confounding factors? So I take it we all have seen those. Anybody here have any idea what a defense expert would say with those confounding factors? Anyone? No one? I think we all know what they'd say. The point of this, that little guy on the big wheel right there is me. This is my life. This is my childhood. This is my mom. And the reason I point that out is not that I'm, you know, you may have your opinions and say, you know what, those things did play a role in Keith's, you know, abilities, but the reason that I bring this out is that be careful. Like we were talking about with the Facebook stuff and all that before, be careful how you use these things, because some of your jurors may have similar backgrounds. Some of your jurors may have those confounding factors. I think Mike was telling me about a jury of 5 moms or something that were, yeah. So just be cognizant of that. Don't always just glom onto those things, because you just never know. You just never know who's going to be sitting out there.
Every once in a while, I look good just because of dumb luck, but I settled a case, and I was telling Keith about this, where I thought that we had a chance of getting hit. The other side didn't think that they'd get hit at all, the other side being a co-defendant. And we settled on a joint tort, $290,000, and then we sat back and we watched the trial play out. The theme for the defense in that case was that this was a individual raised by single parent, African American in Baltimore City, and that was the reason he didn't thrive in school. Okay, well, jury selection put 6 people in the box. They were 35-year-old single parent African Americans, okay, and they got whacked. And it's one of the excess verdicts that led to that insurance company paying not only the full judgment, but interest up to the day that the check got to Mr. Krupelman's office, okay? So, you know, part of what you've heard, whether it's social media or anything else, is you've got to make value decisions on your evidence and the impact of that evidence. And if I was trying a case with Keith, gotta believe sometime I'm gonna hear this in closing argument. So another motion. But, but again, you know, be choosy about what you choose to emphasize at trial. Make sure you know the pluses and minuses. You know, we run things by non-legal professionals all the time in our office to find out what the impact of a fact is or a piece of evidence is. And I'm surprised how, as smart as we think we are, how many times we ignore what is a just common sense reaction from lay people. And that's who we're trying these cases to. You know, I've often wished that I would try these cases to a bunch of neuropsychologists or scientists, but that's not the venue that we're in.
All right. The next topic is coverage issues, and this has been beaten like a dead horse all day yesterday. I'm not going to spend a lot of time with it. In fact, I'm not going to spend any time with it other than to show you the slide that I made, and I apologize if I offend anybody with this one. But this is a case you don't want to sue because there is no coverage here. Even Justin's shocked.
I will add a little bit on the coverage issues. The defense attorneys see it from a different side of the coin than the plaintiff's attorneys. You know, as defense attorneys, the coverage issue is not supposed to be part of what we do. We're defending a client. We're not deciding coverage. But coverage introduces itself all the time. And as Todd said the other day, we do get questions from clients. And we do have a duty to our client to alert them, not really discuss with them what kind of coverages they are, what kind of decisions the insurance company may be making, but alert them as to when it's appropriate to, you know, not just that form letter that goes out about personal counsel, but when there's some change in the case where personal counsel needs to get involved. You know, a lot of us do present to insurance companies on coverage issues in other contexts, and we tell them, and I think everybody tells them, with regard to a reservation of rights, based on what you know, get it out initially, and then as information changes in the case, you need to reevaluate whether or not your reservation of rights is current, does it need to be changed, as facts and evidence changes in the case. Same with your client. You know, when you get that first report and you determine what the non-economic cap is going to be, make sure that's communicated to your client. When you get that economic loss report, make sure that's communicated to your client, and to the extent that those things put them in a less than desirable position, again, just like you may have sent in your initial letter, you're sending them another letter, hey, we've done discovery for 6 months, but now's the time you need to go out and get personal counsel because these issues may have big impacts on how this case goes. You know, maybe that is 0.1 CLE on ethics?
I think you did it. You got it covered.
I got it, okay.
Thank you. Evidence, okay.
There's a couple things about the evidence that is unique to a lead paint case. One is that I represent a defendant who is going to be the first person who's called to the stand during the trial, okay? Doesn't necessarily happen with a construction defect case or a road wreck case, but in a lead case, they're going to be there. And some of the reasons that they've been there is that they're going to be there on the stand first is because they've been there before. You know, it's rare that I get a client who says, my goodness, this is the first time I've ever been sued for a lead paint case. And so we get real estate investors who have multiple lawsuits. And one part I want to just make sure that you understand is that you can guarantee that your adversary has every Barry Mankiewicz deposition that's ever been taken, okay? So you better have every deposition of that defendant. And you need to prepare your defendant to be called as an adverse witness. I had a case where my trash truck caused an accident on the Beltway, and because I I do like to try cases, so that's why I do non-lead cases. But it was just clear from the deposition, he was hostile, he had a short fuse, and he was going to be an adverse witness called first, because the attorney on the other side was just going to just whack him around terribly. So we spent a lot of time getting him ready. And so when the judge said, you know, Mr. Smith, call your first witness, my client was already standing up, walking towards the witness stand, okay? And so when he heard his name, he just sat down up there. And he did a great job. He did a great job. And I thought it was my preparation. As I found out later, after we had a successful case, it was because he took 3 of his wife's Valium that morning. But the preparation certainly helped to keep him calm and to anticipate the questions.
All right. Again, with respect to, you know, trying a case, everybody has their own preferences on how you do it. Some people, I know lawyers in asbestos that think the longer the case, the more people I call, the more experts I have, you know, the bigger the jury will think the case is. I think that's crazy. I think you keep it simple, all right? I'm a big fan of too many chefs in the kitchen spoil the sauce. Call only what you need. I think jurors generally don't want to be there, all right? And if you do have some juror that really wants to be there, you might want to question whether or not you want them on your panel, okay? But in any event, with respect to a lead case, as Mike pointed out, we love calling the landlord first, even if he's a retired fireman from Rochester, because he still had baggage, all right? I think it starts the theme off right for the case. We had the plaintiff. Unfortunately, we have to call at least 3 experts in these lead cases, the pediatrician, the neuropsych, and the economist to give your damages. We'll call the mom and the child, and we'll try to squeeze them in scheduling-wise wherever you can. We generally don't call lay witnesses in our trials. But again, that's a personal preference. That's just the process we use. Now, the topic of this whole thing is not your typical road wreck case. But if you don't try a toxic torque case right, it'll be a train wreck for sure. And how do you not let this happen to your case? How the hell did you manage that? You don't ever want to have that question asked to you. The key, and everybody knows this, is preparation. It's not glamorous, it's not fun, but you got to prep your butt off before you get into trial. I was talking to Gary last night about this, and that's the part that sucks. Okay? When you get in there and you start trying the case, that's when you have fun. But you do your work. One of the most important things in prepping a lead case, as I mentioned earlier, meet your clients, okay? Tell them, honesty wins the day. Do not lie to the defense lawyer. I don't care if it hurts the case. Just tell them the truth, all right? Prep your experts. Humility wins the day. We're going to see 2 videos right now, and you'll see that even when you prep, sometimes things go wrong. Now, before you play this one, this is one of our former asbestos clients. He was a lung cancer, smoking lung cancer. In fact, unbeknownst to the defense attorney, he had been smoking even before the deposition. And he's on supplemental oxygen. It's just a dog of a case. We had a young lawyer, I won't mention his name, at our office maybe 6 months when he did this. And I don't know if you prepped him or not, but you're going to see some things go wrong here. Go ahead.
When did your son pass away?
July. He didn't pass away, he was murdered.
And when was that?
Objection, relevance.
It's not objection because I have the card and the thing.
It's fine. He can say it. You just have to answer my questions. Just focus on me, okay?
Move to strike the comments. It's non-responsive. You told me last week when I had a chance to talk to you that you still smoked cigarettes as recently as 2008. Do you remember that?
Apparently, maybe. I don't remember it.
Okay. Well, let me ask you then, were you still smoking cigarettes on occasion as recently as 2008?
I think I did tell you that I borrowed one off of him, I think, when he come down, if you're suggesting when he come down, had coffee, if I'm thinking the right one. God damn it. Hello?
Tell your clients don't answer the phone.
If you look, this is from the Erie County Medical Center, and you were treated at the Erie County Medical Center, weren't you? Mm-hmm. And it's from December 31st, 2008. And I want to read this to you, and then you can look at it. It says, he does have a long history of cigarette smoking, at least 1 to 2 packs per day for many years. You want to read that?
That's a lie. I never said that. I never said that.
You were treated...
How would I say that when I couldn't even talk?
Okay. Mr. Finian, you were treated at the Erie County Medical Center last...
Right, but wait a minute,
December.
this is getting out of hand. How could I talk when I couldn't even breathe? That's it, right there is a out-and-out lie.
Okay.
I can't even talk, and I'm talking about cigarettes, and I'm dying?
Mr. Finnegan, did you...
That's a lot of baloney. That's a lot of bullshit.
Would you
I
like to
hate
take a
it. You know,
break?
I don't like this shit. Let me have my phone. It might be important. I don't like this one. I'm being as truthful.
Off the record.
Now, I know the lawyer, and he was new at the office. He's a very good lawyer, and I think he prepped him. And just sometimes, no matter what you do, you know, witnesses are going to do what they're going to do. And the next one is an example of that with respect to an expert witness. Now, this is, some of you may recognize him, Dr. Karp, and this is from the Hicks trial last year, Judge Rosenbaum trial that we've been talking about. And in fact, this was not only my first lead witness, but my first lead expert witness as well. And we had a videotape because he was unavailable. To his defense, it was during the time when New York City had all those power outages and he had been sleeping in his office quite a bit. And in any event, go ahead and play it. It's pretty entertaining.
You don't know what is wrong.
The volume.
And you don't know what is wrong to individual children. Now, we're talking about Ashley, who's a reasonably intelligent child who fails first grade. That's Ashley who's my concern here, and not the global epidemiologic question of the fish who fails the IQ test because he can't climb a pole.
Okay. I would move to strike objection. Isn't it also a fact that early on, when Ashley developed a lead level, her lead level was less than 25, right? Her first lead level was 21?
That's correct.
And when was that? What's the date on that?
Well, the date is 1991, so by the time she had the 34, it was 10.
Right, but early on, when she had a 21, 21 was less than the current standard of 25 because the CDC report is October of 1991, correct?
Okay.
Am I right?
Sure.
Right?
Sure.
And New York didn't lockstep immediately send out directives to all the physicians, correct? Took about a year and a half for everyone in New York to figure out that
yeah,
the
that's
CDC
true.
had lowered the
Objection.
standard. Objection. Okay. You don't know, correct?
I do know, I was right
No.
there.
If you look at, I think it's Exhibit 2, when is the 1991
No,
printout?
October of 94.
Okay,
91. Right. No, I agree, I understand exactly what happened. I remember when the report came out.
Right.
And then I had to notify all my doctors, and all
Right.
the doctors, hey, no, the reference
Right.
is 25. Oh, yeah, are you sure it's not 25? Why is it 25?
Right.
Et cetera, et cetera. Sure, human behavior doesn't, it's not like turning left at a street corner. It's like moving a battleship.
Right.
You know, it takes a long time.
And in fact, in the old days prior to the lowering of 10, it was a two-part process, right? It was a lead level of 25 and an FEP level of 35, right?
Oh, the FEP. That's another discussion of FEP.
I don't think we need it.
We
but
do. You want that? Okay, here we go.
No, we don't need it. I'm just asking you. The lead
Well, I
level,
think-
lead poisoning was defined as a lead level of 25 and an FEP over 35, correct?
No, not exactly right. FEP levels. Okay. So when the hemoglobin molecule doesn't form properly.
All I asked was a yes or no.
No. The FEP over 35 would trigger you to do more. Well, I'm going back to when I was doing this, but I think the high FEP level would then trigger a risk factor that you had a better check for lead. We used the screening of the lead. We used the screening of the, that's right now, I have to, wait a second. Okay, we used the screening of, well, I have to go back to 1985 for this, so, you know, let's see. Okay, so the screening test was the FEP, which is when the hemoglobin molecule doesn't form properly. And that could be either iron deficiency or lead poisoning. So we'd have to then, when you got the FEP over 35, then we go and do the lead level, and it was a lot more difficult to do a lead level. But that's all been thrown out.
Right.
Not exist anymore. Except the little itching cramming in my brain, like, whoa.
Thank you, Doctor.
Thank you so much. Bye.
So, again, you know, unfortunately, This was actually played to the jury.
And you won the case with
and
this
we,
guy?
And we won the case. The jury can look at this and say, oh, he's cute, he's kind of funny, he's quirky, or they could say, this guy's a nut job. They said the latter, but we still won. The jury did not like this video at all, but we still won, and we're being yanked. So I thank you for your time.
We do have one question, and this issue raises its ugly head in Maryland on occasion, and the question for our panel is, what are your views on bringing a motion to compel IQ test of the mother? Pros and cons.
There was a time when we routinely took and tested the mother's IQ. And I'm not sure what exactly happened that as a group we kind of abandoned that. But we try a lot of times to get the mother's IQ into evidence without testing. There's more than one way to skin a cat. And sometimes the best evidence of IQ is having her on the stand. And not one of these 10-minute fast, Israeli commando raid type of witnesses, but, if the plaintiff needs her for a reason, make sure you take advantage of that time on the stand and demonstrate that there's not so much difference. Cats don't make dogs, okay? If for whatever reason the plaintiff doesn't feel they need to get mom on the stand, we put her on the stand, or we attempt to put her on the stand for primarily that reason, but certainly it's not a sham. There's other valid reasons that we called her as a witness. But that's been pretty much the practice of everybody that defends cases now.
All right, thank you very much. We'll take our break, and we'll be back at about 10:35 or so.